number 237,934. This is in the interest of Alea and Ogwin Ogwin minor children, non-custodial party being Jose Alea Perez, custodial party being Claudia Ogwin. And this matters before the court on a motion to modify child support and motion to confirm arrears. Of course, taking judicial notice of the court file, note for the record. I think everybody's present, and Mr. Gott with the picture firm is representing Mr. Alaya Perez. Is that correct?
It's Ayala Perez, yes, but I'm here.
All right, then. Anyway,
I apologize, Your Honor. I didn't know Mr. Perez was present. It looks
Well,
like
my office called him after we scrambled on this.
Okay.
So.
Hello, I'm here.
Okay. All right. So at this time, the court will note that the state's president, the council's president, Ms. Ogwin present.
So Gein's not here, but I'm here for her, Judge.
Okay, then. All right, then. And so the attorneys are all present. So what are we looking at doing here today, folks? Again, I remember this one a little bit, but I've had 100 cases since then. So yeah, go for it.
All right, Judge. Just to raise one issue that Mr. Gaunt may or may not address is that our office did send a notice of hearing. We have a certificate of service that it was sent on August 15th of 2025 to Brett Pritchard's office at the email address that they normally have, and that was sent on August 15th. So based on that, Your Honor, the state is asking that we enter the proposed order that was signed, that was attached to the motion to enter. I will tell the court that the state initially filed the suit for modification of support order and motion to confirm support arrearage back in July 25th of 2022. There was a final hearing that was held in January 12th of 2023. And then there was a proposed order that was drafted by the private attorneys and that was provided to me. However, that order was never signed and was never submitted to the court. So the state drafted the order that was attached as Exhibit A, including the new child support amounts, which were ordered on the January 12, 2023 hearing. And we're asking that be entered. And so, Judge, what that's going to do is that's going to change the child support amount, increase it to $850 a month beginning February 1st of 2023. And cash medical support based on that hearing was ordered at $234 to begin February 1st, 2023. And since then, Judge, both of the children have already emancipated. So we're asking that the court enter the order based on its ruling from January of 2023. And that's it, Judge.
I believe those dates are wrong.
Stop. Your lawyer you don't get to, sorry, your attorney speaks for you, sir. Sorry about that.
Okay.
Thank you. All right, then. And the court will, I am looking at the docket sheet from January 2023 to 17th, and it appears that it was supposed to be an agreed to order was proven up at that time. Mr. Gahn.
Okay, a couple things. Number one, we don't have notice of this hearing. I'm not saying we didn't get it, but we don't have it. My client certainly didn't know about it. But here's the deal. This order, I'm looking at my notes from back in the day. Hold on, let me pull them. Okay, the first issue, yes, the order from January 2023 was never entered. Mr. Pender and I had agreed with that. So my client was in future pay because the AG never got the new order rate at $850 a month. So if we're entering an order effective 2023 for $850 a month, I'm fine with that. I haven't seen a copy of this order. The problem is that the 18-year-old male, he emancipated. He was still in high school. He turned 18, but he never emancipated. So my client agrees that the son was in high school until I believe the following May, and I think lived with mom. So we've got an issue of resolving the fact that child support may have needed to carry forward. And I think one of these kids was also on Social Security, if I understand. The biggest problem is that the daughter at the time, the last time Jordan and I looked at this case, the 17-year-old she was living on her own. She was actually living here in town, and she was working, and she was in high school. So the question was, what do we do with the child support? Because the child's not with mom. And so we were asking that step down to 636. So the 2022 mod has never been finalized. That was our concern. And again, if we can get that done, that's fine. But since January 2023, one child didn't emancipate in high school and the other one has moved out. And so, yeah, the 18-year-old has SSI. So that was the question, is trying to get all this sorted out. This is kind of an unusual circumstance here. So I can't just robo-sign this agreement or agree to it. Respectfully, I would ask the court to take notice of this and take it under advisement and look at it. Those are the only outlying facts I had, was that, again, I had an 18-year-old male that turned 18 but was still in high school. And then I had a 17-year-old that was still in high school but had moved out and was living on her own and working on her own and wasn't living with either one of them. And then
Well,
the 18-year-old was
unfortunately,
receiving
Mr.
SSI.
You know as well as I do, unless that order changed that, or if she was emancipated, child support still doing it until she turned 18, sir. If she was on her own at 18, obviously.
Well, but who does he pay it to? She's not living with the mother.
Well, the original court order says that child support goes to mom, unless there was a change in there somehow.
Are we on the record?
Yeah, we are.
Okay. Yeah, I'm basically reading my notes in, and I'm not
Yeah.
throwing stones here, but this is a very complicated case and very exotic, kind of an exotic fact pattern.
Right.
So I haven't seen the order. I do agree that for whatever reason things got missed in 2023. And if it needs to be, if it tracks the original order, that's fine. The outlying facts since then, that's fine. My concern was that my client was either going to be in future pay or get slapped with arrears immediately. And I think the AG had advised me off the record that there was some money on hold. So I just need the court to take notice of those two issues and work it from there. My understanding is that, again, the 18-year-old was receiving SSI as well. There was a question about receiving an offset for the medical, but I think Judge Carey resolved that.
Yeah, because it's only SSI that was the child's benefit, not based on mom or dad. So yeah.
No, I understand that, but typically it would be an offset to the child support. It would be an out-of-pocket offset.
State. Judge, may I respond?
I was going to let the other counsel go first, but okay. So go ahead.
Yeah. Judge, we're asking that this order be entered. I understand that there may have been some issues that have come up since then, but both Mr. Gaunt and Mr. Pender, who's no longer the attorney, Mr. Bowden, is here for that law office. They've had an opportunity to file a motion. This has been pending for over 2 years. They've had an opportunity to file any motions that they wanted to address, to seek a modification. They were set in court in November of 2024. I met with the parties. They had an opportunity to discuss it then, to see you then at that time, Judge, and that didn't happen. So it's been several months. So we are asking this order be entered per the court's ruling. And then again, we show that we stopped the support just for Mr. Gaunt's purposes. We stopped the child support in June of 2025, so recently, for the last child.
Okay. All right then. And who's representing mom now? Sorry, Mr. Bowden.
I am Judge Marcus Bowden. So
Right.
my 2 cents is the only question today is whether the proposed order accurately reflects the ruling that was rendered in January of 23. Based on talking to my client and the notes in the file for Mr. Pender, I believe that it does. So we have no objection to you signing the order and finishing this phase of the case. All those other issues are, potentially going to be raised if an enforcement ever surfaces or whatever, but let's get the order entered and move on.
All right, and of course, I can always do a clarification later on based on the circumstances that happened after the order, but the order is as of January 2023, correct, Ms. Taylor?
Yes, Judge. It will go back to start the higher amounts in support to begin, I believe, February 1st of 2023. And Judge, I will add that the only change in the order that's been proposed, and I'll send it to Mr. Gaunt again, but the only change will be the first page, which shows that the parties actually appeared with their attorneys. I'll have to change that to show that the parties did not appear. Oh, I'm sorry, Mr. Perez did appear. I'll have to show that Miss Olquin did not appear, but her attorney did. So that's the only change I'll have to make.
Well, that doesn't need to be changed. That's saying on January 12th of 23, that's what happened. And that is what happened. So that's correct.
Well, I was going to add to the first page, Judge, that there was a hearing held on that date, but then a hearing was held on today's date for order entry.
Okay. All right, then, folks. This has come up before on these type of cases. I got to go ahead and enter an order that was based on the time and place of the circumstances. And obviously, once that one's in place, anything else that needs to come up after that, anything else that would may be clarified after that, to be done in a proper motion. But let's go ahead and let's get this one entered. Let's let the calculations start and let everybody start doing the math on what needs to be done. Okay. But again, this is just looking at as of January 2023, and I would is that it's not the court file already? If you filed it electronically, Ms. Taylor?
It was filed electronically, Judge.
Okay, I hadn't checked the electronic stuff anyway. So let's go ahead and enter this, and like I said, as of that date, and then because and that's the dad
Excuse me, Judge.
sir, again, you got a lawyer, you can't do that. So you got a question you want to ask of your lawyer, sir? I'll let you do it. But right now we're in the middle of a hearing, sir. So, Mr. I'll tell you what. I'll take a 5-minute recess. Allow Mr. Gaunt to talk to his client because obviously his client's got some. Yeah, Mr. Gaunt, you want to talk to your client, sir?
Yeah, I do, because for the record, I don't have a copy of this order. There were two different copies that were submitted by my office and by Mr. Pender's office. Again, I'm not saying the order's wrong, but I haven't seen the bloody thing.
All right.
Okay, I will send it to him right now, Judge. If we could take it, give us, I guess, go against a couple more cases, give us about 15 minutes, and Mr. Gahn can also review the order right now.
All right, good enough then. Thank you. All right, we're out for about 15
Okay, if you want to put me in a breakout room with my client, I appreciate it. Thank you, Judge.
Thank
Yes.
you.
Thank you.
Share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.